All right, we're back. As you all know, we've been making videos to help you guys learn how to assert yourself and properly object when needed. Even if you don't know the proper objection or the grounds for it, object anyway, because we are structuring your appeal, okay? And what is appealed is the errors that the judge makes, not necessarily the errors that the plaintiff or defendant makes, and that's why we appeal, because we're appealing the decisions of the judge and the errors that he's making, whether they be palpable errors, egregious errors, emoluments well, it wouldn't be emoluments violations necessarily, but would be more along the lines of procedural errors and so on and so forth. And we're going to start talking about pleadings now. Outside the pleadings, as you've learned from our teachings, the only issue properly before the court at any time during a lawsuit are those issues properly raised by the pleadings. So the old maximum, that which is not included is excluded. And that's very important because a lot of people like to use heart and emotion. I'm one of those people that used to do that heavily, and some of my mentors would look at my pleadings and stuff, and they would just throw them in the fucking trash. I wouldn't even read them. They go, Derek, if I'm not going to read this, I'm going to tell you right now, a judge isn't going to read this. It's 90 fucking pages long, filled with fucking emotions, like you got sand in your fucking vagina, buddy. And I hate to hurt your feelings because I can see that you're passionate and you got a lot of emotion. But the court doesn't give a fuck about how you feel, what you thought, any of that. All they want is the cold, hard fucking facts, and whether or not those facts breached a trust or breached the law. That's it. They don't care that when the officer pulled his gun, it made you feel like your life was in danger. They don't give a flying fuck about how you feel. They just want to know that when you were assaulted, a man was brandishing a weapon without proper authority to do so. He had no reasonable articulable suspicion, and he had no reasonable articulable fact for engaging you in the first instance. That's all they give a shit about, okay? And they don't give a fuck how it made you feel, or that it made your sister cry, or that everybody around you was scared for your life. They don't fucking care. It doesn't fucking matter. It's outside the scope, okay? So these are very hard lessons to learn. A lot of people that write me and show me their pleadings, I go through and just redline shit all fucking day long, and they get all butthurt about it. Trust me. I used to get butthurt too. My mentors are brutal. They're rude, crude, and socially fucking screwed. They don't give a damn about how you feel. There are certain facts that are just the way they are, and this is one of them. Nobody gives a fuck about the sand in your vagina, so give it up. We don't care how it made you feel. We want you to articulate the facts and what constituted the violation of your unalienable rights, okay? Period. Cut and fucking dry. All right? So I'm not here to be your friend. I'm not here to sugarcoat this shit. I really don't care how it makes you feel. I'm just here to spit the facts, all right? So again, the pleading is going to be narrow in its subject matter, all right? And anything that's outside of that subject matter, outside of the pleading, is irrelevant. That which is not included is automatically fucking excluded. So you'll see times where a judge from the bench, when you're talking about something that's outside the scope of the pleadings, will tell you, I don't want to hear it anymore. I've warned you once. If I got to tell you again, if you bring this issue up again before this court, you know, I'm gonna remove you from the court, or maybe I'll appoint you an attorney because you just don't understand what's going on here. Okay, and you're hampering the proceedings by throwing in your fucking conjecture that's outside the scope. All right. Now, with talking about pleadings, there's a time when you can amend the pleadings. If something comes to your recollection that isn't in your pleadings but needs to be made part of the subject matter, the scope and the focus of why you're moving a suit, then there are times to amend that pleading. You gotta let the court know, hey, I need to amend this pleading. There's some pertinent information in here that's relevant to the subject matter and the scope. My intent is not to broaden the scope of the suit, but rather just make sure that everything is all inclusive. And they're going to grant you that opportunity to amend your pleadings to make sure that, you know, for example, in your pleadings, you only put one officer and there are three officers there, and you want to make sure that those three officers are included in the suit, whether you're doing a 1983 action. I just recently learned about the Monell 1983 action, which is pretty interesting. Still don't have that all figured out yet, but where there is a will, there is a way, okay? So we're talking about pleadings again. The only issue properly before the court at any time during a lawsuit are those issues properly raised by the pleadings, and only those that were properly raised by the pleadings. Once the pleadings are closed, no more issues can be raised for the court to try and decide in favor of one side or the other. The parties both have their opportunity to raise their competing issues in the pleadings. Once the pleadings are closed, however, those issues are sealed and remain unchangeable through the remainder of the lawsuit. And the reason for that is if you were allowed to just amend your pleadings at whim because you all of a sudden had an epiphany or remembered something, it would be a long, daunting, drawn-out process that would never end. And for the lawyers, I'm sure they would love it because they feed on controversy. However, there's got to be some kind of form that leads to a resolution in short order because justice should be swift, without delay, and without cost, okay? Pleadings. The pleadings tell us what the case is about. They should have been clearly stated in the plaintiff's complaint. Defendant's answers and affirmative defenses and plaintiff's reply to defendant's affirmative defenses. Those are the pleadings. Nothing else is. Once pleadings are closed, they are like papers locked away in a compartment of a sunken ship. They cannot be changed without the court's permission. Everything the case is about, claims, arguments, facts, and objections, is now secure in that sunken ship, waiting for the parties to present evidence to prove the facts they allege and to present their respective legal arguments to establish who should be favored by the court's final judgment. The compartment is sealed. Without permission from the court, we cannot go back in and change them or add to them. Don't allow the other side to confuse the court by raising issues halfway through your lawsuit that were not raised by the initial pleadings. Once the pleadings are closed and there remain no motions addressed to the pleadings by which they might be amended or amplified, new issues cannot be raised unless you fail to object. So remember to object anytime that the opposing attorney is outside the scope of the pleadings and making issues that aren't part of the pleading, all right? You have to object. It would be like arguing with your spouse about some single thing he or she wants you to change about yourself, and then, just as you begin to prevail with some justification that would defeat the dispute, to have your spouse change the subject and complain about something new. Lawyers are notorious for this shit. I can't tell you how many of them have called me a scumbag, that I'm a con artist, prove that you've won a case, and then I turn around and show them a wedding signature from the judge and the prosecutor of me acquitting myself on a case, and then they go, yeah, well, you left a bunch of securities on the table and everything else, and you abandoned your property. Oh, way to change the subject matter, motherfucker. First, I'm a fraud, and now instead of a fraud, I'm a lackey who just didn't have the knowledge at the time to collect all my rights, titles, interest, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, child security, trust residuals, trust residue, rents, profits, proceeds, futures, and annuities from the case. Now I'm some kind of fucking way to change the subject matter. You see how that works? Lawyers are notorious for this shit. As if the first issue was no longer of any importance. This is a commonplace tactic among unhappy couples, but it isn't fair and it tends to destroy both affection and trust. In court, it is absolutely forbidden unless you fail to object. No new issues can be raised once the pleadings are closed. It isn't fair fighting and the rules forbid it. All too frequently, however, an unscrupulous or stupid lawyer will try to raise new issues during the proceeding of a case. Issues never raised by the pleadings. There are only 4 types of pleadings in any case: complaint, answer, affirmative defense, reply to affirmative defense. There may be a counterclaim, cross-claim, or third-party complaint, but these are only variant forms of complaints and are therefore pleadings. There may be answers to counterclaims, cross-claims, or third-party complaints, but these too are only variant forms of answers and are therefore pleadings. If an issue of material facts has not been raised by the pleadings, we say that the issue is outside of the pleadings or beyond the four corners of the pleadings, the four corners of the paper, the four corners rule of the paper, which is exactly what your court is. Or we use some other description to explain that the issue is not properly in controversy and therefore not properly before the court because it was never raised by the pleadings. When the other side tries to obfuscate the real issue in your case by raising new issues that were never mentioned in the pleadings, this is your response. Objection. That issue is outside the pleadings. I've done this successfully many times. Each time the judge orders ceasefire while he thumbed through the file to find the pleadings. He read what was said in the complaint, the answer, and the affirmative defense and replies. And if the newly offered issue was not made a part of the pleadings, he prevented the other side from clouding the case further by bringing in a new dispute that was not part of the central controversy. Very effective. A common abuse by unscrupulous and stupid lawyers. Don't allow it. Object. Remember, as taught more completely in our other step-by-step materials, every case stands or falls on the party's pleadings. The plaintiff raises issues in his complaint. The defendant responds with his answers denying at least some of the facts alleged by his adversary. We call this like a confession and avoidance or a negative affirmant. You can also do your special appearance and, of course, your demur. Things like that come to mind when I'm hearing what this lawyer is articulating here. The defendant's responds with his answer denying at least some of the facts alleged by his adversary. Then, if he's studied our course, the defendant raises issues of his own with affirmative defenses. Finally, the plaintiff responds to the defendant's affirmative defenses with a reply by which he denies some of or all of the defendant's defenses. There then may follow what calls a flurry of motions directed to the pleading. This is basically battle by forms is what they call it. It's paper battle. Motion to strike, motion to dismiss, or motion for battle of the forms is what it's called. Battle of the forms. Motion to strike, motion to dismiss, or motion for a more definite statement. Once these attacks directed to the pleading are disposed of, if any are filed, we say the pleadings are closed. At this point, we should know clearly what the case is about, i.e. if the parties did their job the way we teach. The battle lines are set. Both sides have declared what they now intend to prove. All that's left is for each side to outdo the other by offering the greater weight of admissible evidence in support of the facts they allege in their pleadings, and to argue successfully that the law of the jurisdiction demanded that the court grant the winner the relief he seeks. Once the pleadings are closed, neither side is permitted to raise new issues unless the court grant permission to amend the pleadings. You will encounter this crooked tactic often. However, when a lawyer cannot win fairly, he will often try to confuse the court with issues never raised in the first place, issues that are outside the pleadings. The good thing for you is that most judges welcome the chance to simplify cases that come before them. They don't want their docket to be jammed, their cases running overtime, or their decisions delayed. Upon your motion, they will gladly stop the parties from introducing new issues that are outside the pleadings, because by doing so, they make things easier for themselves, reducing the time to close the case and to get on to the next. Good for you, but it only works if you object. A talented but unscrupulous lawyer, given a free hand by your failure to object in a timely and effective manner, can so completely twist the facts and confuse the court with new issues outside the pleadings that the issues originally raised by the pleadings are lost completely in judicial waters they have muddied by their clever evasion of the rules. If you aren't on the lookout for the corrupt tactics. Before you know it, they will have the judge entering final judgment against you on issues that were never part of the lawsuit in the first place. Fortunately for you and all good people favored by our American rule of law and the principles and practices of due process, the game of litigation is controlled by a set of regulations that favor the good guy, i.e., the person who should win. Parties are not allowed to introduce new issues into a case once the pleadings are closed. It isn't fair. It isn't American. The days of winning by ambush are over. Trial by ambush. If you object, that's it. Prejudice. The word prejudice comes from the roots that refer to the judging of a thing in advance of hearing all the facts. In lawsuits, you'll encounter there'll be times when the other side will offer facts that are more likely to prejudice the court rather that provide any proof of value. They may be offered to embarrass you or simply to shock the conscience of the court against you. Regardless of the other facts of the case that are in your favor, we say the prejudicial effect outweighs the probative value. A lawyer for the other side may try to prejudice the court against your witness or inflame the court with wild or extreme disturbing facts that attack human emotion in a way that may tend to influence the court's decision contrary to reason and the facts. In such circumstances, you object. Objection, Your Honor. The prejudicial effect of this testimony completely outweighs any probative value it might have. Prejudicial testimony may be relevant and yet excludable upon objection if, as stated, its prejudicial effects outweighs its probative value. An example might be a gruesome photograph or a horrendous injuries suffered by a young child involved in an automobile accident. Hospital bills and testimony of physical therapists as to the degree of impairment the child will suffer are admissible evidence of the child's damages, without bloody photographs of mangled limbs that could serve only to influence the court to award greater money damages than the circumstance may truly warrant. The offer to produce such a shocking photograph will result in your complaining. Objection. Your Honor, the probative value of this evidence is outweighed entirely by the shocking prejudicial influence it is likely to have on the court. More commonly, prejudicial evidence will be offered to undermine the court's confidence in your honesty or the merits of your case. You might hear something like, this as opposing counsel for the defense examines one of your own plaintiff's witnesses. Isn't it a fact that the plaintiff owes you money? Or how often in the past 10 years has the plaintiff failed to pay your wages on time? Or worse yet, is it true that the plaintiff cheats at golf? Don't let this sort of thing slip past you. If the testimony is prejudicial, if it tends to influence emotion more than reason, if it has the unwanted effect of encouraging the court to rule against you in spite of the facts and the law, object. You may not convince the court to put a stop to it. You may not convince the court to put a stop to it, but you will preserve your objection for appeal. And who knows, that may be the turning point in your case. When we come back, we're going to talk about qualifications.